Those things obtain and you will be able to get maintenance for children. I'm speaking about the cohabitants, the adult participants in that relationship. And there is a limitation period within which you must bring the claim. There are two limbs in terms of the claim, so that you can bring the claim simply for maintenance, or you can bring the claim seeking financial adjustment, which is along the lines of property. So that when you speak of claiming property and interest in property, or perhaps there is a business which you're saying that we participated in, those things are in the nature of the financial and a property adjustment order. That is one area that you can seek relief, but you can also seek relief simply by asking for maintenance. But the point is that you must initiate your proceeding within the time prescribed by the Act.
You're having brunch with us here at 107.7. It's great to have you here. The area of educational, I want to go back to that just for a moment, because we touched it, and I don't know if I precisely placed my question. Maintenance may also be granted to allow the applicant to increase their income. This is one who's seeking maintenance relief from the court. Applicant to increase their income by pursuing a training program or educational course.
Yes. It is all part of what we call maintenance. In other words, you see, there might be circumstances where you become engaged in a cohabitational relationship, and you may have decided that you will stay home and attend to the home and the family. Years have passed. You have not been a part of the labor force.
Right.
You cannot you are now 10 years older. You have not learned how to use a computer.
Not marketable.
You are no longer marketable just by virtue the sheer fact that you have been off of the work market for that period of time. And therefore you may need to upgrade your skills. You may need to go back to school to do something so that it increases your income earning capacity. And it is that which there can be provision made for that. And that would be by virtue of paying for the cost of your going to a refresher course or to going to pursue some educational program in an institution and so on. And those costs can be borne by the cohabitant, by the person whom you were involved in a relationship. The other thing is that people quite often assume that, in fact, the application under this act is being made by women. There is, perhaps it is part of, how our society operates, that we think that men don't seek relief from women. It's just not macho enough. But what I wanted to point out is that whether you are male or female, because there are, in this Trinidad experience, you find that especially where you do find situations where your partner, the male in the relationship may have been laid off. They may find themselves in a situation where increasingly they have in fact been homemakers. They act in the role as homemakers. And it is conceivable, and it does in fact take place, where you do have the woman going out to work, and the man is actually seeing to it that the children get off to school. The children, they pick them up at school, they do things with those children, and they may find themselves in the position where at the end of that relationship, they are the ones that are disadvantaged. So that the application can be made by the male or by the female.
Gender neutral is what we're talking about.
It is definitely.
Attorney Hyacinth Griffith, I want to go, and because I cannot have you leave while we start leaning up against the time without going into a couple of areas of domestic violence.
Yes.
And one of the questions I know that's repeatedly asked is how difficult it is to get one and have it enforce a restraining order.
Well, let me...
What is the level of...
The question of the domestic violence legislation also came out of the context where previously seeking that type of relief or protection in a family context, there had been no legislation which dealt with that specifically. You had to go by way of an injunction, it was injunctive relief, or you went in the in the magistrate's court, in terms of where you have been there has been an offense committed, and you're seeking, some relief in terms of a charge, a criminal charge, etc. So that the Domestic Violence Act really was born out of the clear need to protect persons who have a family relationship. So that relationship, the Domestic Violence Act is not for strangers.
Mm-hmm.
The Domestic Violence Act is for persons who have a relationship, cohabitational, by marriage, by blood.
Mm-hmm.
And in a context where you find that those persons quite often live together in a particular environment, maybe the home, or with the breakdown of that relationship, they are now living in separate places.
Mm-hmm.
And one person continues basically to terrorize the other. So that the Domestic Violence Act really came to offer relief very quickly to persons who find themselves in a situation where they are the subject of violence.
And let's be
domestic
very,
violence.
And this is not just physical but psychological.
No, and that is yes, and not just physical or psychological, financial,
Mm-hmm.
emotional,
Mm-hmm.
sexual. And what I want to say in terms of, we need to understand that the abuse, I am of the view that the worst abuse is actually the abuse you cannot see. And
does the legislation reflect this?
No,
okay.
It's just a personal view.
Mm-hmm.
But I want to say that we need, as a society, to be more sensitive. And we perhaps need to be sensitized to this, to understand that because someone does not present with the physical marks of abuse does not mean that that person is not being abused.
Very true.
And so we must be aware that abuse takes various forms.
I actually concur with you that the deeper, well, I don't like to quantify pain,
Yes.
but an area that is underestimated
Yes.
is that area of the psychological abuse.
Yes, yes. Because you see, the thing is that it is the area you can get away with, and when the police turns up, they say, "Well, I ain't doing nothing."
Mm-hmm.
You know, this very and if it is that our security services, our police and others, our neighbors are not aware that in fact it can take place very definitely without any physical markings.
Yeah.
We then miss, in fact, most of the abuse.
Yeah, and a lot of folks don't understand that the physical manifestation sometimes in the understanding of causation is a result of a lot of things leading up to it.
Yes, and in fact what we also need to understand is that this abuse occurs right across every class of our society.
It is 15 minutes away from the top of the hour. I want to continue in this area, and I want to give you a scenario because it was raised, and I said interesting. A man and a woman, whether it be in marriage or cohabitation or whatever, any kind of relationship, let us just say they live together. Okay, so let's go cohabitation or marriage. And they get into a disagreement. The disagreement gets out of hand. They get to blows. It doesn't matter who occasioned it. He hits her, she hits him. And the neighbors, just out of concern, call the police and say, we've got a disturbance. The police gets there. And both parties, both adults say, listen, we had a disagreement. It got out of hand. We don't want to press charges. We just want to leave it alone. What happens? What does the police officer do in a case like this?
If you have persons who do not want to press charges, and there is not something which the police can in fact charge you if it is that they, for example, if there's some physical manifestation that the police needs to intervene, if they can see that there has been a criminal offense committed, there might be evidence of the person having shown injury which is quite apparent, the police can charge. But you need to understand that the person who you need to give the evidence is the person who has just told you, I do not wish to charge.
So
this
both
person.
parties say we do not. We neither of us want to press charges. It's not because some folks believe that the police should take you and let the court decide this because many women or many people, but more specifically women, may be under a unspoken threat. That psychological thing we talked about.
Yes.
So when the cop shows up, you go like, no, it's all right. But it's not all right. The minute he leaves, we return to status quo. So a lot of folks say that in a case where a police officer is called there and both parties said no, he should still continue to lay charges, to arrest, separate both parties, and let the court decide that?
Well, the thing is that I think that we have to be prudent about this, because if you do that in terms of every situation, we already have a clogged court.
Yes, okay.
So you're going to have matters called where people say they are not coming to court and the police basically just wasting their time.
So the training of the police officer.
The training of the police officer is important. But apart from that, even if, and it is very real, that if you are in a situation where you are the subject of domestic violence and there is grave violence, and you are in fact in fear and intimidated by what has transpired with your partner, you may not be in a position to actually say to the police, I want to charge him when the police arrives. You just, because if you were to say that, unless you are in a position to go somewhere, you have someone that the police can take you to, you might find that as soon as the police leaves, now you're really getting it. So that what might be, what actually happens on several occasions is that, first of all, you have 6 months within which to bring your complaint. You can bring a complaint in terms of an incident or a chain of events which took place, but you are limited by the limitation period is 6 months, so that you can speak of anything that has happened within the last 6 months. If you find yourself in a situation where you have made a decision that this is really, I am at risk and I do need to leave, it may be prudent for you to put certain things in place for your own safety in the immediate short term. And you can still bring your complaint within that period, within the 6 months.
I'm glad you said that.
Now, the second thing, though, is you can also go to the court for an ex parte order, so that if it is that something has transpired and you are literally in fear, and it happens quite often, you have gone to the police station, you have gone to the doctor, there are marks, there is physical evidence as well of you being at risk. You can, in fact, go to the court and seek what is called an ex parte order, which is an order made in the absence of your partner for your protection. And that order offering you protection can be simply to restrain the person from doing an act which constitutes a domestic violence, or that order can be made to exclude that person from the home. And that order can be made ex parte, so that you receive that immediate relief. And that order can be made whether those premises are rented premises, whether those premises are the premises that he owns, and in other words, he owns by himself. You do not own it with him. It can be in respect of the premises where it belongs to his family, but this has been your home.
Right.
The court can make an order that he is restrained from returning to those premises.
Fantastic.
For a fixed period. Now, if the order of the court is made ex parte, there is a return date of 14 days. So that it's not like the court is going to exclude him from the house and he doesn't get an opportunity to be
We
heard.
will give you the order on the basis of the evidence you have provided.
It's urgent.
In his absence,
Yes.
but we are going to give him a chance so we can hear his side of it.
He must be
His
given
own.
an opportunity.
He or she.
He or she must be given an opportunity to be heard and to be heard fully. Because you can consider the mischief that can be created if the person is not given an opportunity to be heard. So that at the end of, after that person is given an opportunity to be heard, the court makes a determination what is the appropriate order to be made by way of a final order in this matter, having heard both sides fully.